think so, yes.
All rise. Court is now in session. I will Sherry Madej presiding.
Please be seated. Good morning, everyone.
All right, this may sound routine, but don't tune out. This is the constitutional safety net in action. Everything the judge is laying out here, these rights are non-negotiable. Speedy trial, jury trial, silence, counsel. This is the legal firewall between the power of the state and the individual. And here's the key takeaway. If you don't understand these rights and accidentally waive one, that mistake can follow you for the rest of the case. This is the calm before the storm.
Ladies and gentlemen, this morning it is my duty to advise you of your constitutional rights. These instructions are important, so please listen carefully. Under the Constitution of the United States and the state of Ohio, persons charged with the commission of an offense are guaranteed certain basic rights. They are the right to know and understand the charges against you, the right to a speedy trial, the right to a trial by a jury, or you can give up that right and have your case tried directly by a judge without a jury. At trial, the state of Ohio has the burden of proving your guilt by evidence beyond a reasonable doubt. You have the right to meet your accusers face to face and to cross-examine witnesses for the prosecution. You also have the right to summon or subpoena witnesses on your own behalf. You do not have to testify against yourself. You have the right to counsel. If you're unable to afford an attorney, the court will appoint a lawyer to defend you. You will be assessed a $25 fee for an appointed attorney. You will not be denied an attorney if you're unable to pay this fee. At the end of your case, you may be ordered to pay the fee if your judge determines you are financially able. If you choose to hire your own attorney, you have a right to a reasonable continuance to hire one. You are not here for the trial of your case this morning. You are here for your arraignment. An arraignment is your opportunity to be informed of the charges against you, for bond to be set, and for you to enter your plea. You do not have to make any statement about the charges against you, but any statement made by you can be used against you. As your name is called, please step forward. You will be asked when you received a copy of your indictment or information and whether or not you understand the charges against you. By law, you have 24 hours before you must respond to the indictment or information. If it has been less than 24 hours since you received a copy of your indictment or information, but you wish to be arraigned anyway, you may waive the 24-hour notice and we will complete your arraignment this morning. If your case is going forward by way of information, I will ask your attorney to place on the record that they discussed with you waiving presentment of your case to the grand jury. You will be asked 4 questions. If you understand the charges against you, if you knowingly and willingly signed the waiver, if you consent that charges proceed by information instead of indictment, and if you wish to continue to be arraigned by waiving the 24-hour notice and the reading of the information. You will be asked how you plead. A defendant may plead not guilty, not guilty by reason of insanity, or with the consent of court, no contest. If you want to plead guilty and you do not have an attorney, the court will assign counsel for you so that you may have a full understanding of your constitutional rights. Your case will be assigned to a judge whether you plead guilty or not guilty. If you refuse to plead, the court will enter a not guilty plea on your behalf. If you have been charged with the crime of violence and/or drug offense, under Ohio law, you cannot knowingly have, carry, or use a gun, a firearm, or a dangerous weapon until your case is concluded. This is called being under a disability. If you violate this disability, you could be charged with a separate felony offense in addition to the original charges you are being arraigned for today. Even if you have a CCW permit, you are still under a disability until your case is over. In fact, upon indictment, the sheriff who issued the permit shall suspend it until your case is over. Finally, if you are over 18 and you have not provided a DNA specimen since 2011, you may be required to submit one within 24 hours of your arraignment. Inmates in the county jail have the right to be present in the courtroom. Mr. Corrigan, do you have anyone in the jail that wishes to be in the courtroom this morning?
Two men, Your Honor, Mr. DeQuan Martin and Rodney Cuthbertson. We're going to send them over tomorrow.
Okay, thank you, Mr. Corrigan. We're ready for
You're
the
welcome.
first case.
We'll start in courtroom, case number 630080, co-defendant A, Devontae Nettles.
Good morning, Mr. Nettles. How are you today, sir? Good. Do you have an attorney?
No,
Do you have the money to hire one?
I'm going to get one soon.
Okay, tell me who you're going to hire. Do you know? Okay. All right. The court will appoint 2 attorneys because of the nature of this case to represent you, all right? Have you received a copy of your indictment? And when did you receive it?
Yesterday,
Yesterday? Has it been 24 hours?
probably.
Okay. All right. Do you understand the charges against you?
Yes.
Do you wish to waive the 24-hour notice so that we can proceed today? Okay. Do you wish to waive the reading of the indictment in open court? You have the right to have me read you the entire indictment in open court. Do you want me to read it to you? Okay, so you waive that? Okay. By waiving it, it means you're giving that up. Okay. Do you wish to enter a not guilty plea today? Okay, sir, I accept your not guilty plea. The court will appoint attorneys Fernando Mack and Rufus Sims to represent you in this case. Your bond is set at $5 million. That's it.
$5 million. That's not just a number. That's the court quietly telling you how serious this case is. Cash, surety, or property bond means the judge believes this defendant poses a major risk, flight, danger to the community, or both. Translation: pre-trial freedom just became nearly impossible. When bond hits this level, the courtroom energy shifts, and everyone knows this case is headed somewhere heavy.
The cash, surety, property bond. You're ordered to have no contact with the surviving victims in this case. Your case is assigned to the docket of Judge John Satula. Your first pretrial will be on July 11th at 9 a.m. Okay? Good luck, sir.
Andrews. Co-defendant B, Montez Andrews.
Mr. Andrews, how are you this morning? That's not you? Are you Mr. George? Okay. Can we do Mr. George? Okay.
Set for the co-defendant C, Aaron George.
Mr. George, do you have an attorney, sir?
No, I have to get me a lawyer.
Okay, do you know who your dad's going to get you?
No,
You don't know his name? Do you know if your dad has paid anyone yet? He has paid him?
Like he put a house up for that.
He put his house up? Could that have been for your bond?
No, for my lawyer.
Okay. All right. Do you know if your lawyer was supposed to be here this morning?
No.
You don't know? Okay. All right, Mr. George. Have you received a copy of your indictment?
Yes.
Do you understand the charges against you?
Yes.
When did you receive it?
Yesterday.
Yesterday? Has it been longer than 24 hours?
No.
No? Okay. Do you wish to waive the 24-hour notice so that we can proceed today?
Yes.
Okay. Do you wish to waive the reading of the indictment in open court this morning? Do you know what that means?
No.
Okay. So you have the right to have me read the entire indictment to you in open court.
I want you to do that.
You want me to read it to you? Okay. Thank you. Okay. This is the matter of the state of Ohio. How do you pronounce your first name?
Aaron.
Oh, okay, you're not Mr. Andrews. Aaron George. The state of Ohio versus Aaron George. Case number 630080. Dates of offense, June 20th, 2018. Count 1, aggravated murder. This is an unclassified felony in violation of 2903.01C. The jurors of the grand jury of the state of Ohio, within and for the county aforesaid on their oaths, in the name of and by the authority of the state of Ohio, do find and present that the above-named defendants, on or about the date of the offense set forth in the county of Cuyahoga, unlawfully did purposely cause the death of S.N. 2009, who was under the age of 13 years of age at the time of the commission of the offense, to wit, February 6, 2009. There are 3 firearm specifications on count 1. The first is a 1-year firearm specification pursuant to 2941.14A. The grand jurors further find and specify that the offender had a firearm on or about his person or under his control while committing the offense. The second firearm specification is a 3-year firearm specification pursuant to 2941.145A. The grand jurors further find and specify that the offender had a firearm on or about his person or under his control while committing the offense and displayed the firearm, brandished the firearm, indicated he possessed the firearm, or used it to facilitate the offense. The third firearm specification is a 5-year firearm specification, drive-by shooting, pursuant to 2941.146A. The grand jurors further find and specify that the offender committed the violation of section 2923.161 of the revised code, or the felony that includes as an essential element purposefully or knowingly causing or attempting to cause the death or physical harm to another, and that the offense was committed by discharging a firearm from a motor vehicle other than a manufactured home. The state of Ohio reserves the right to seek a superseding indictment containing the appropriate 2929.04A aggravating circumstances specifications. This offense is contrary to the form of the statute in such case made and provided, and against the peace and dignity.
This is the gut punch moment. Aggravated murder. A victim under 13. Multiple firearm specifications. Each of those specs isn't just descriptive, it's additive. 1 year, 3 years, 5 years, stackable prison time before the base sentence even begins. And when the state mentions a possible superseding indictment, that's a warning shot. This case isn't shrinking, it's expanding. At this point, the arraignment stops being procedural and starts feeling inevitable.
Of the state of Ohio. Okay, that's all count 1. There are 10 additional counts. Would you like me to keep reading? No? So you waive the reading of the remainder of the indictment in open court?
Yes.
Okay, sir. Do you wish to enter a not guilty plea?
Yes.
Okay, I accept your not guilty plea. Because you don't have counsel with you right now, I am going to assign counsel to represent you to make sure that you're represented through all the proceedings in this matter, okay? If you choose to hire or retain a lawyer going forward, it's an easy fix. They can file a notice of appearance, okay? All right. Mr. George, the court appoints Attorney Thomas E. Shaughnessy and Attorney David Grant to represent you in this case. Because of the nature of the indictment, the court will appoint 2 attorneys to represent you, okay? Your bond is set at $5 million. That's a cash surety property bond. You're to have no contact with the surviving victims in this case. Your case is assigned to the docket of Judge John Satula. The first pretrial is on July 11th at 9 a.m. Okay?
Co-defendant B, Matza Andrews.
Good morning, Mr. Andrews. How are you this morning? Okay. I need you to speak up just a little bit louder, all right? Do you have an attorney, sir?
No.
Do you have the money to hire one? Okay. The court will appoint 2 attorneys to represent you in this case because of the nature of the indictment. Sir, have you received a copy of the indictment?
Yes,
When did you receive it?
2 days ago.
2 days ago, so it's been longer than 24 hours?
Yes,
Do you understand the indictment?
yes,
So you understand the charges against you. Do you wish to waive the 24-hour notice? So you're allowed 24 hours before you have to come and stand before the court and enter a plea. You've had it longer than 24 hours, correct? So you're okay with waiving that 24-hour notice?
Yes.
Okay. Do you wish to give up the right to have your indictment read to you in open court? Okay, do you want me to read you the entire indictment right now in open court? No? Okay, so you want to waive that? Okay. Do you wish to enter a not guilty plea today?
yes.
Okay, I accept your not guilty plea. The court will appoint attorneys James McDonnell and John DeCaris to represent you in this case. Your bond is set at $5 million. That's a cash surety property bond. You're ordered to have no contact with the surviving victims in this case. Your case is assigned to the docket of Judge John Satula. The first pretrial will be on July 11th at 9 a.m. Okay? All right, that's it.